Hello, I'm Laura Dawson. Welcome to a new episode of the Advocates Lounge. Today we'll be exploring the significant amendments introduced under the 185th Practice Direction update. I'll mainly be focusing on the amendments to Practice Directions 51R and 51ZB. So the 185th Practice Direction update has added a few significant amendments to Practice Direction 51R and 51ZB. These changes aim to essentially modernise the civil litigation processes in England and Wales. They mainly do this through the online civil money claims pilot, or the OCMC pilot, and the damages claims pilot, the DCP. Both of which are relatively new introductions into civil litigation. So let's delve into the updates and their implications and any challenges that they may present. So firstly, one of the key amendments to Practice Direction 51R that I'm going to talk about first is mainly the introduction to fixed costs. So a new fixed costs regime has been introduced for the claims process under the OCMC pilot. So fixed costs now apply to any claims exceeding £25 where judgment is entered in default or on admission. Fixed commencement costs are now calculated based on the claim amount, which is outlined in the Civil Procedure Rules Practice Direction 45. Further, there are now new costs limitations. So claimants' legal representatives can only recover fixed commencement costs and additional fixed costs which are specified in Table 3 of Practice Direction 45. And if defendants settle the claim within 28 days of the issue date, then no further costs are recoverable unless ordered by the court. Another further amendment is really the extension of this pilot scheme. So the OCMC pilot has now been extended for a further 12 months, now running until October the 1st, 2026. So now let's look at some of the implications of the amendments to Practice Direction 51R. First really is around sort of cost predictability and efficiency. So claimants will now benefit from predictable legal costs tied to the claim value, which can reduce the risk of them incurring excessive fees, and it means that they get an overview of exactly how much their claim is going to cost them from the start, whereas before usually you get the cost bill at the end, and there's a bit of uncertainty leading up to the conclusion of the case and progressing the case, whereas that uncertainty should now be gone. It also means that defendants are more incentivised to try and settle the claims promptly to avoid them incurring any additional costs, which can lead to faster resolutions in claims. There's also the simplification of cost recovery. So the fixed costs regime is there to streamline cost recovery, which essentially eliminates the need to justify or negotiate any legal fees beyond the fixed amounts. It also encourages early settlement. Again, defendants can avoid further costs by settling within 28 days, again reducing litigation burdens on courts, solicitors and parties. There's also an impact on any legal representatives. So this it encourages legal representatives to adapt to the fixed cost framework, but this can also potentially limit their ability to charge any higher fees for any straightforward claims. There's also been an extension to the pilot duration, which provides more time to evaluate the fixed cost regime and any procedural changes, to allow any feedback to be adapted into the regime going forward, to essentially make the system more effective, really. So now let's take a look at some examples to the amendments to the fixed costs regime. So the fixed commencement costs are now calculated based on the claim amount, which is outlined in Table 2 of CPR Practice Direction 45. Let's take, for example, now a claim of £500. The fixed commencement costs will be determined by the corresponding rate in Table 2. These costs are included in the claim form and recoverable by the claimant if judgment is entered in default or on admission. Let's look at a scenario in relation to judgment in default. So let's say a defendant fails to acknowledge service or respond to the claim. The costs that would be included and recoverable by the claimant would be the fixed commencement costs and any additional fixed costs as specified in Table 3 of Practice Direction 45. So, for example, a claim of, let's say, £1,000, the claimant may recover fixed commencement costs, for example, £50, as in Table 2, and then additional fixed costs, say, for example, £22 for judgment in default. Let's also now look at an example on judgment on admission. So a defendant admits a claim and proposes, say, a payment plan that the claimant accepts. The costs included and recoverable by the claimant again would be the fixed commencement costs and then any additional fixed costs as specified in Table 3 for judgment on admission. So to take, for example, a claim of £2,000, the claimant may recover fixed commencement costs, for example, £70 in accordance with Table 2, and then any additional fixed costs outlined in Table 3 for judgment on admission. One of the aims of the amendments, as I've outlined previously, was to encourage or incentivise early settlement. So let's take, for example, the defendant pays the claim amount, the court fees, and fixed commencement costs within 28 days of the claim issue date. The outcome is that no further costs are recoverable unless the court orders otherwise. So let's take, for example, a claim worth £500. So if the defendant then admits the claim and settles the claim and pays the claim amount of £500, the court fees, and then the fixed commencement costs, all within 28 days of the issue date, then the claimant cannot recover any additional costs. These examples are really just to illustrate how these new fixed costs are applied to essentially streamline the cost recovery process and to encourage early resolution of claims. There is a slight downside, I suppose, to the new fixed costs regime. It does limit the amount of costs that are recoverable, whilst it means it's more easier for claimants to understand what their claim is going to cost them. It will also impact legal representatives' costs, as they are now severely limited in what they can recover. Say, for example, a straightforward claim, this might not particularly matter, as it's now more in proportion for the costs that are incurred compared to the complexity of the claim. However, if we've got a very complicated claim, even though it's not worth a lot, the costs to be recovered are relatively small, probably compared to the amount of work that a legal representative would have to do for such a claim. So this is a factor that I suppose solicitors would need to take into consideration when discussing the costs or anything like that with any clients that they have that have come to them. So we've had a look at the key amendments to Practice Direction 51R. So now let's go on and look at the amendments to Practice Direction 51ZB. The first amendment is that the damage claims pilot portal has been extended by a further 12 months, now running until October the 1st, 2026. Secondly, it's now mandatory for legal representatives and legally represented parties to use the damages claims pilot scheme. So therefore, any legally represented claimants and defendants must use the DCP for damages only claims in the county court. Claims must be for damages only and must meet specific conditions which are outlined within the practice direction, for example, not being governed by Part 8 procedures. There have been also some procedural adjustments. So there's been detailed rules for filing, service and time limits have now been introduced, including the use of the My HMCTS portal. There is also now automatic dismissal for non-compliance. So essentially claims are automatically dismissed if procedural requirements such as notification and service deadlines are not met. Claims that are deemed unsuitable for the DCP pilot or ones that fail to meet the procedural requirements are going to be automatically transferred out of the pilot scheme. Now let's move on to look at some of the implications of these amendments. So let's first talk about the streamlined process for the damage claims. The DCP provides a structured online process which reduces the administrative burdens and improves efficiency for damage-only claims. There's also increased accessibility. So because of the mandatory use of the DCP, this ensures uniformity in handling damages claims, making the process more predictable. There is also encouragement for procedural compliance. So the automatic dismissal of claims for non-compliance, again, will incentivise strict adherence to the procedural rules, which will mean claims are probably dealt with in faster and more streamlined. It also enhances case management. So again, detailed case management procedures will ensure that claims are handled efficiently and effectively. There's also been limitations on scope. So the DCP applies only to damages-only claims, excluding other types of claims such as those governed by the Part 8 procedures. There is also an impact though on legal representatives. So again, legal representatives must adapt to the DCP's procedural requirements, including, as I've mentioned before, the use of the My HMCTS portal. So it'll be something which a lot of legal representatives now need to be more aware of, and especially the encouragement of the compliance with the procedural rules and obviously the consequences of the automatic dismissal of the claims if those procedural compliances are not adhered to. So again, it's something which solicitors would need to now be aware of if they are handling a damages-only claim. So now let's look at some challenges and considerations for both of the amendments to both of the practice directions. Firstly, about scope limitations. So fixed costs under the practice direction 51R apply only to claims exceeding £25, while the DCP is limited to damages-only claims. So this does restrict the applicability for certain parties and certain cases. There is also an adaptation period which needs to be considered. Legal professionals and parties involved in civil claims need time to familiarise themselves with the new rules and the procedures, especially, as I outlined previously, the strict adherence to procedural conditions within the DCP. There is also the risk of the procedural dismissals following on from that. So again, the automatic dismissal of claims for non-compliance. This does pose a risk for parties who are unfamiliar with the DCP's rules. There is also the potential for underrepresentation. So fixed costs may deter legal representatives or solicitors or certain firms from taking on low-value claims, which potentially will leave some claimants without adequate representation, meaning they either have to do the claim themselves and will therefore be very unfamiliar with how the process works, potentially leading to severe consequences to them, or they may not even bother to litigate their claim in the first place, which will obviously force them to potentially not have compensation that they would rightly deserve. So the last topic I want to talk about is the sort of emerging themes and patterns. There is a big shift now to digital transformation. So both Practice Direction 51R and Practice Direction 51ZB reflect a broader trend now within the legal sphere towards digitalisation in civil litigation. and using and utilising online platforms to help streamline the process. I think essentially gone are the days when we would have reams and folders of paperwork which we have to send in the post to the court or to the other side. We're moving a shift now towards a more online process where instead of posting documents, you upload them to a general platform which the court and the other parties can easily access. This also has to be factored in terms of clients who are not necessarily familiar with the digital age or the technology required. There is also a focus on efficiency. As explained previously, these amendments aim to enhance efficiency, predictability and fairness in civil claims, essentially levelling the playing field for all parties involved. There's also procedural rigour, so emphasis on strict procedural compliance, which highlights the importance of clarity and consistency in civil litigation. So in conclusion, the amendments to Practice Direction 51R and Practice Direction 51ZB represent a significant step towards modernising the civil litigation processes. By introducing fixed costs and mandatory online systems, these changes aim to enhance efficiency, accessibility and procedural compliance. However, challenges related to scope of the limitations, adaptation and procedural rigour must also be addressed to ensure the success of these pilot schemes. Also, with the shift towards a more digitalised system, law firms and legal representatives need to become more aware of how these processes and pilot schemes work to ensure compliance with such schemes if law firms deal with a lot of these types of cases which would run under such schemes. So thank you for listening. I hope that was useful and keep an eye out for the next episode in the Advocates Lounge.